Hello and welcome to this lecture on law and the legal system for the ACCA qualification Corporate and Business Law. My name is Stuart Murphy and I'm going to be your tutor for this series of lectures. Brought to you by Viva Financial Tuition. Hopefully you enjoy learning about the law as much as I enjoyed learning about the law. So what we're going to cover in this first lecture, we're going to be talking about different types of law. We're going to be talking about the court system in England and Wales. So there's two different types of courts. We've got civil and criminal courts. So what is law? So we can think of law as a set of rules that govern how we behave within society. Law is there to help us resolve disputes between us. And in terms of governing our behavior, it's there to make sure we maintain social order. And we have two different types of law, which we're going to cover. We have criminal law and civil law, and they fulfill different parts of this definition. The English legal system includes, we have common law and equity. So we'll run through where the laws in England and Wales came from, so a bit of history. We had originally common law, and equity was added on top of that. We've got private and public law, so some laws only relate to private individuals, and some laws relate to everybody. And then we have criminal and civil law. So these are the two big types of law we have. And, criminal law, that helps us fulfill the first and third bullet point there when we think about the definition. So with criminal law, we've decided certain things are wrong. And if you commit those wrongs, then you'll have breached our social order. Civil law, on the other hand, that's about the second bullet point there. It's there to help us resolve disputes between us, such as, say, breach of contract that we'll cover on this course. So where did the laws come from? So originally we had common law, and this goes way back to 1066. And that was when we were conquered by the Normans. And what happened was there was a bunch of legal experts who were sent out to investigate what the local customs were of the land. And then they came back and they debated what they thought was the best custom out there, and they developed the common law. So now all laws became the same no matter where you were in England and Wales. So they were based on local customs at the time, but they had to pick the best one and then make that the standard. Developed this idea of precedent. So precedent means if I make a decision as a judge, then future judges are bound to follow the same decision. So I set a precedent, and that is the basically the future decision. If anyone brings the same case in again, they will get that outcome. The only remedy was monetary, so damages. So these days we're told that we live in a litigious society, they say, where everybody's willing to sue each other. But in fact, this goes all the way back to the inception of law. And if you look back at the old documents, there's something called the writ list, which was a list of wrongs. And actually on there, it has the compensation. So for example, if somebody damaged my thumb, I would get, say, 50 shillings. If somebody damages my hands, it might be 500 shillings. So there were set amounts of payouts. Okay, that's a good example of a precedent. So a judge decided that a thumb injured is worth 50 shillings, and then another judge decided that a hand injury was worth 500, and now that's the outcome for all future cases that are the same. The problem was over time they became rigid and inflexible. So there was that writ list, it was called, i.e. a list of wrongs, and if I could prove it was part of that list, then I could bring a case. If not, then I wouldn't be able to bring a case. It was very hard to bring new cases, being very bureaucratic and sort of tick boxy. So then equity was developed, and equity was came from the king at the time, and the idea was that they thought that there was some unfairnesses being caused by common law, and so they said, right, okay, we're going to add equity on top of common law, and that's going to prevent these injustices. The idea was it was more flexible, so now if there was a case that had never been heard before, it was easier to bring this new case. In fact, at the time there were different courts. There was common law courts and equity courts. So if I didn't think I could get onto a common law court because I wasn't part of that list of wrongs, I would take it to an equity court. It's a lot more flexible. Primary focus was fairness for all the parties. So rather than just, say 50 shillings for your thumb, if that wasn't the right outcome, we could come up with a different outcome. In fact, there were different remedies available. So we had this specific performance, injunction, and rescission. So we'll go into these a bit more when we do the breach of contracts lecture. But just for example, let's say that I've hired somebody to build me a new house and they don't build it to the exact specifications. Well, that's where specific performance would come in. So they might say, well, I'll just give you some money. But it's really hard to say, well, how much am I out of pocket? Maybe it's not possible to change the house because, it's just going to be way too expensive. So now I can get the builder to come back in and fix my house. Or let's say that I have some land and people keep walking across my land. If it was a rich person who was taking a shortcut across my land, they might be able to afford to just pay me damages. But that's not really what I want. I want them to stop doing it. And that's where an injunction would come in. So this is where the judge says stop doing it. And then rescission is where we just tear up the contract and go back to our pre-contractual position. So if I buy something from somebody and let's say it's absolutely not what I wanted and money's not going to sort it out, then I could appeal for rescission and say, right, I just want to give them that thing back and I want my money back. And then the last one there is estoppel, a bit more of a complicated one. We'll come back to that when we get into the breach of contract there. But in effect, I'm stopped from breaching a promise I may have made in the contract. So private and public law. So private law is there to govern the disputes between individuals. So it'll only cover the people involved in the case, not everybody. That would be if it was public law. Individuals take private matters to court, such as contracts and tort. So we're going to cover breach of contract in the course, and we'll cover negligence, which is an example of tort law. And family law, we'll not cover that too much on the course, but just to be aware, then again, might have a private dispute, say over adoption, then it would only involve the people, it would only affect the people involved, not everybody. And then company law, so we'll see some examples of company law. Maybe as a shareholder, I want to sue the director of the company, and we'll talk about whether you can and can't do that. And then we'll also cover insolvency law, so how do I liquidate a company? Or what happens if a company gets into difficulty, which is a slightly different process. We call that administration. And then public law focused on the government. So if you work in the public sector, as in you work for a government-owned organisation such as the NHS, there'll be laws that govern how the NHS operates, and they'll affect everybody. Relationship between the state and its individuals. So let's say I did decide to take the NHS to court and I won. Then the NHS would have to change. That would affect everybody because it's a public organisation. The powers and rights of those in office. So if you're an MP or a mayor of a city, what can you and can't you do? So power can, rights, what rights do you have in terms of protection? Duties, what do you have to do, I guess? And then maintaining social order. So if the police take me to court and prosecute me, maybe this is for something that's never been seen as a crime before, then judge decides, yes, this is now a crime, then that helps to, it adds to the social order of things, right? More rules we have to follow. And then covering areas such as constitutional law, administrative law, and criminal law. So constitutional law, we're not governed specifically by a constitution in England and Wales, but there are certain laws that are seen as foundational. Administrative law, so this is how the government would run. And then criminal law, what's right and wrong within society, and that affects everybody. So a big distinction, criminal law and civil law, common exam topic here, so make sure you're happy with this table. So the big difference between criminal law and civil law is criminal law regulates behavior within society, whereas civil law is more about the individuals involved. So again, kind of similar idea to public law and private law. So criminal law, we say the state prosecutes the accused, or we call them the defendant, whereas I would bring a case if I wanted to sue somebody for breach of contract, then I would sue them. They would be called the defendant still, but then they'd be called liable. And I would have to bring the case and the claimant instead of the state. Cases reported as RE, so Regina versus a name. So it would be RE, it's in the King or Rex versus or Regina. So at the moment we're Rex, unfortunately, since last year. So it would be Rex versus Murphy, and that would tell you I was being prosecuted for a crime. Whereas if it was a civil law case, then it would be something like Murphy v. Murphy, or we tend to say Murphy and Murphy rather than v when we're talking to about the cases. So civil cases involve two last names, and most of the cases we're going to see on this course are going to be civil cases. Good news is you don't need to remember all the case names. The stories are just there to help us illustrate how the law actually works. State has a burden of proof beyond a reasonable doubt. And then we've got standard of proof is balance of probabilities. So basically, state has the burden of proof in criminal court. They've got to prove that you did something wrong beyond a reasonable doubt. On the civil law, the claimant has the burden of proof, and the standard of proof we aim for is the balance of probabilities. So if I'm suing you for breach of contract, I have to prove on the balance of probabilities we had a contract and you did not fulfill that contract. Now, just pause for a moment and think, which one sounds higher? Which one sounds like a higher standard of proof? So the higher standard of proof is beyond a reasonable doubt. And bear in mind, these are different courts with different rules, such as the standard of proof we have to achieve. And so in a criminal court, I might be found innocent because they can't prove I did that crime beyond a reasonable doubt. But on the other hand, in a civil court, I could be found liable. And this reason here, because the standard of proof is a little bit lower. So beyond a reasonable doubt means no reasonable person could doubt that you did it. Balance of probabilities means there's more than a 50-50 chance that you did it. And then if you have committed a crime, you get punished. So there'd be fine or prison. Whereas in civil law, we tend to try and compensate the person who is wrong. So if I'm the claimant and I brought the case, then I would usually get enough money. Damages is still pretty often the remedy. So damages means money in law. So money's pretty often the remedy, and I'll get enough money to compensate me as if the breach of contract had never happened. And one event could give rise, as it says, there's parallel proceedings in both. So if I was, say, for example, drink driving, and I happen to injure somebody, so I would be prosecuted in the criminal law for drink driving, and they'd have to prove beyond a reasonable doubt that I was driving drunk. On the other hand, the person I injured could sue me for negligence, and they would do that in a different court, and they would just have to prove on the balance of probabilities I was drink driving, and that drink driving led to their accident. So you can have one incident that gives you liability under both.